Good afternoon, everybody. I'm Kim Coble. I'm the Executive Director of the Maryland League of Conservation Voters, and it's great to spend Friday at noon with you again. Our Friday Digest series is something we put on for our members. It really is important for us to understand how we can help you be informed and inspired to take action. So please let us know in the chat or in the survey that we'll send afterwards what topics you want us to cover, what questions you might have, how we can be helpful in facilitating you to be a strong, informed activist. I'm very excited about today, and I'll talk about that in a moment. But a couple housekeeping things, definitely fill out the survey afterwards. Also, put your name and where you're from in the chat just so we can keep track of you and make sure you're on our lists. And also, if you have any questions for Evan or myself, please put them in the Q&A or the chat, and we'll try to get to them at the end of the conversation. So with that, we'll go ahead and get started. This is, we have had the conversation about this bill before on Friday Digest. This is SB 937, Senate Bill 937, House Bill 1035, the Next Generation Energy Act. And we've been concerned about this bill since its introduction and continue to be working with the legislature about it. I will say, hot off the press, is that we've been informed that there are going to be some amendments to the bill that may address some of our concerns. So we want to acknowledge that late-breaking information and also thank the members of the General Assembly that are working with us and hearing our concerns. So that's great. We haven't seen any language, so I can't speak to it, but we're hopeful that we can get this bill in good shape before it passes. Real quickly, let me do a quick overview of the bill. What it is doing is it's creating an expedited process for what they're calling dispatchable energy generation. And this is a very technical definition, and I'm not going to define it in detail right now. What it does, though, is it opens the door for the potential of new gas plants to be built. That type of energy would be a provision under this bill, as would battery storage. So there's some good things here that we want to support. So we're not in favor of opening up new gas in Maryland. We talked about that in the past, but today's focus on this bill is not that. We want to focus on the expedited process that's been presented in the bill. How are we going to expedite this? How are we going to make sure that these gas plants or battery storage or whatever is getting built is fast tracked so it can get deployed as quickly as possible? And the bill as drafted has some very concerning language in our minds that it's really this expedited process is, we're very concerned about that. And I am really pleased today to be joined by Evan Isaacson. Evan, I've known for a long time and have a world of respect for him. He's a senior attorney and director of the Environmental Action Center at the Chesapeake Legal Alliance. Evan brings lots of experience in environmental law, policy, particularly around water issues in the Chesapeake Bay and environmental justice issues. But Evan has a great, he owns the intersection of the law and policy, probably as well as anybody I know. And so in some ways, he's here to speak to that intersection of the law and policy, not even just generically, more so than even with this bill, but we'll get into that in a moment. Let me set the stage and then we'll turn to Evan. The expedited process that's in the bill is actually on the last page, the last 4 paragraphs, and it says that if a site has been used or is currently being used to generate electricity and produces greenhouse gas emissions, so this, you can consider sites including existing coal sites, coal burning power plants, oil burning power plants. Those sites are now eligible to have the dispatchable energy developed on that. And if those sites are, if there's a proposal to build something on these already dirty sites, an expedited permitting process will, or excuse me, an expedited review process will be incorporated. And that expedited review process includes the actual elimination of the law that specifies public notification. So there's parts of the Code of Maryland that specifies when you have a proposal or an applicant, here are the steps that you need to do to notify surrounding communities. And you need to advertise in the newspaper. You need to hold a public meeting. You need to have a liaison that would work with the community. You need to have information that is exchanged and presented to the communities. You also need to present this information to the municipality where this facility is and the county where this facility is. All of that is removed. Just eliminate it. So there would be no public notification at all. That's a big concern for us. The other thing that concerns us is the law. It then goes on to say that the Public Service Commission, who would be reviewing the proposal, and this is actually specified in the bill, it says, shall presume that the site is okay, that there's no site evaluation, there's no soil tests, there's no review of the site. The commission shall presume the site is safe. And then the last part is a very, very wide sweeping statement that says the Maryland Department of the Environment, the Department of Natural Resources, the Public Service Commission, and any other impacted agency, although impacted agency isn't defined, and I quote, shall waive or expedite any regulatory requirement that could interfere with the timeline. So the idea is to build these things very quickly, but that is being done by removing public input, county input, municipality input, review, site review, and an indeterminate removal of regulatory requirements. So that is a big concern for our organization. So Evan, great to have you here. Thanks for joining us. And let me start with just a quick preamble. Why don't you share with our members here a little bit about the Chesapeake Legal Alliance, what you do, how you do it, why you do it?
Yeah, sure. I'll be extremely brief. I think our old tagline says it all. We're lawyers for the Bay. So we have a small but mighty team of in-house lawyers and then a much larger network of attorneys, our pro bono volunteer attorney network. So if people have a legal need in the environmental community or a concerned community, they'll come to us and we'll either take it in-house or place it with an attorney in our pro bono network. So we also do legal education, which is similar to what we're doing today. And then, we dabble in legislative advocacy from time to time, but I leave it to the professionals at LCV for that.
Thank you. So, you heard the preamble of the bill, and I know you've read it as well. But you deal with a lot of permits and a lot of regulatory actions, mostly in the water arena, some a little bit broader. But let's just talk generically about the importance of public notification and county and municipal notifications. What role does that play in the process that you think is critical?
Yeah, I mean, just to back up, public participation was built into our environmental laws from the get-go. When Congress was devising our bedrock federal environmental laws 50 years ago, public participation was drafted right into the statutes, like the Clean Water Act, right up top. And Maryland, similarly, over the decades, has passed a number of statutes that put public participation rights right in there. It is a right that all of us have, and a right that very clearly is being trampled upon here in some of those problematic provisions. So yeah, it's we could not do the job we do without those laws, because if we don't have public participation rights, if we don't have public notice, then it makes it extremely difficult for the average Marylander to exercise their other environmental rights, to appeal a permit or to enforce a permit, for example. So it's critically important to the work we do.
Kind of a bedrock of environmental work, is what I hear you saying. So let's talk a little bit specifically about environmental justice concerns,
Mhm.
because the communities often around, um, unfortunately, many of those communities around polluted sites already suffer from or overburden underserved communities as well. So, how could removing public notification exacerbate the environmental justice concerns?
Yeah, it was. I mean, my eyes popped out when LCB staff first sent this to me, because that particular citation to Maryland regulation flagged something for me, and I went and double checked, and that's the exact provision of Maryland regulations that was amended after a Civil Rights Act lawsuit
Mm,
was settled between EPA and the federal DOT with the state of Maryland. It was over a CPCN, so that's what's at stake in this bill. It was over a CPCN process where it was alleged that there was racially discriminatory practices, and so they came up with this settlement. And as part of that settlement, they drafted the exact provision that this bill would then be sidestepping. So
mm,
there aren't all that many places in law or regulation that explicitly discuss environmental justice. This is one of them, and this is directly being ignored or sidestepped by this bill, by that
wow.
provision in the last page.
And there's maybe you can spend a little time talking about the interaction between the federal regulations and state regulations. Maryland is responsible for implementing state law, or excuse me, federal law by an agreement. But so, what are the implications then to the federal requirements that the state has?
Yeah, that's a great question. I think, a reviewing court would be scratching its head looking at that provision. At best, it's inartfully drafted. At worst, it's flagrantly illegal. So, that subsection G basically says you shall expedite or waive all of these different requirements. Well, as you alluded to, some of those requirements are federal law. A state cannot waive federal law. So it would either be struck down or it would be narrowly interpreted. There are certain provisions you simply cannot waive or expedite because the state cannot do that to federal law. There are other laws that are state law that I suppose you could argue would be waived or expedited per this statute. But as a former legislative drafter, you can't draft something like that. If you want to amend a particular process to waive or expedite, you actually have to put that in the bill and explicitly do so. You can't have one paragraph that just says this other litany of
Hmm.
statutory requirements are now expedited or waived. It was mind-boggling to see just highly unusual language like that being
Yeah,
attempted here.
yeah. It was frightening to read that. I kept reading it over and over and again, thinking I just wasn't understanding it correctly. But and the ambiguity in it also, one could say an impacted agency might even be the Department of Management and Budget and Management and pertain to income tax or labor and pertain to the OSHA requirements, So it really, the door that opens is frightening. So it's good to know it's not legal, but
I
hopefully,
think it was pretty intentional too. If the
mm,
bill specifically and explicitly described the various things being waived or expedited, the
right.
General Assembly might say, well, wait a minute, we don't want to do that. We don't want to do that to this, and this other law that we passed recently. We don't want to, they referenced Comar 2079-0104 without explaining what I just explained, that this was what the state agreed to in order to resolve a Civil Rights Act complaint, right? They don't
Actually,
call
that's a
that
great
out. It was very anti-transparent, and very clear what they're trying to do.
right. Right. Yeah, no, that's a very good point. And I just saw a question come up about with the Trump administration and the rollbacks that just we're just starting to see 31 of them this week alone. Um, it, it there's a consistency between what's in this bill and that approach, right? The lack of transparency. Am I overstating that?
No, not at all. And I mean, it was a very so I consulted with a few attorneys I know who spend more time in energy and utilities law and just asked them their opinion on all this. And one of the terms that was used to describe that provision was extremely heavy-handed and
Mm,
one might say very Trumpian. It was just, I don't want to take the time to understand the way the law works and work through what needs to be expedited or waived. So I'm just going to put in one sentence that says, environmental law, we don't need it. Public participation and transparency, we don't need it. Environmental justice, we don't need it. We're just going to boop, pop this provision in and see what happens.
mm.
It's not the way legislation is supposed to happen. It's not the way the Maryland General Assembly usually drafts bills. So yeah, it's fairly stunning.
I appreciate that point, Evan, because as someone that's been doing this work for a while, I had the same thought that this is not the way Maryland legislates. It just we're smarter, we're more thoughtful about it, and so I again I just want to emphasize our understanding is that there are going to be amendments to clean this language up. So um, we thought it was important to bring it to our members though because it is so serious that it definitely needs to get cleaned up. One of the questions, another question that came through. So the way the bill's written, we know that this would apply to a gas plant per se, but since the bill also applies to battery storage, would this same expedited process and the same, you don't have to have public notice, all of those things provide to clean energy sources as well?
Yep, I would assume so. Yeah.
Okay.
I think what ought to happen if they really want to expedite the permitting process for a project that everybody agrees is a good idea is to give the agencies the resources they need to do their permitting a little bit more quickly. That's the way you expedite. Or if there's a particular provision that's really hanging things up, put it in the bill and let the General Assembly discuss it. I understand that they want to put their thumb on the scale for certain types of energy projects, and that's a policy choice that they can make. There's a proper way of doing it, and it's just not being followed here, at least not on the final page of that bill.
Yeah, that's a great point. What you touched a little bit on this. Let's play worst case scenario in the language. We can't get it changed. It goes through. Do you feel there's legal actions that a community could take if there was a proposal that um, they found out that something was being built, and how would a community or members of the community respond?
That's a great question. I mean, every one of those laws that's effectively being sidestepped, circumvented here, has its own built-in provisions that allow for citizens to either challenge agency action or, challenge a particular violation. So there's no shortage of potential, legal mechanisms that could be employed if the bill were to pass in its current form and arguably other laws are being ignored or violated. There's a way to challenge that. There's also the existing PSC process. What I don't know off the top of my head is what to do with that agreement that the state signed in 2019 with the federal government to resolve the alleged Civil Rights Act violation. That's
Mm,
something that would need to be explored. And notably, that agreement was signed during the Hogan administration and Trump 1 administration. So,
mm,
you know, it, there was pretty widespread agreement that we need these guardrails to protect communities in Maryland, even back then in 2019. So, uh,
right.
those communities would absolutely need to be notified immediately after this bill passes that, your rights are being infringed upon.
Hmm. Um, and I think going back to the previous question. What I want to make sure people understand, and maybe you can help emphasize here, is that this concern about this language is not specific to the gas proposals. This is not specific to dirty energy. This is specific to community and individual rights and environmental protection, environmental justice, public health. So maybe if you can just emphasize that point a little bit so folks understand that what the magnitude of what is lost here.
Yeah, exactly. So, well, two things. One, I would be concerned if this bill passed, it would enable and incentivize future legislation to copy that language. And we'll get to the
Mhm.
point where it's just one bill after another, effectively trying to do away with our existing environmental laws as they are at this moment. Our environmental laws are sort of layered carefully on top of each other over the decades to address one problem after another, um, all the while balancing things like, economics and other important policy considerations. So you carefully crafted a system that works. You don't just wipe it all away. But to answer your question more specifically, the Clean Air Act, Clean Water Act, and Endangered Species Act, and a dozen or so state laws are all part of the CPCN process now. So it already attempts to consolidate environmental regulation and different statutory frameworks within that proceeding in order to expedite the process. So it already has that function built in at the Public Service Commission through the CPCN process. But yeah, any number, more than a dozen different statutes are essentially being complied with during the CPCN process. So whether it's your stormwater or your critical area commission laws, erosion and sediment control, air laws, all of those things. Once there's a CPCN application that comes in for whatever type of project, all of that permitting is happening at the same time within the framework of that CPCN application. So, again, if there is a particular sticking point that the utilities are having a problem with, that's what needs to be a part of the discussion with this bill. Let's figure out where that logjam is, why it's happening. Is it a lack of staff? Is it a particular feature of the law that needs to be debated? So yeah, that's the appropriate way to fix that problem.
That's a very good point. Um, I'm starting to look at questions that are coming in here. So let me feel like we talked about some of this. So one question that came through I want to address is what these provisions are specific to sites that already have existing energy infrastructure, if you will, that either used to or currently are producing energy and putting out greenhouse gas emissions. So, uh, for the audience, that these are all over the state. We have a list, thanks to some partners that helped with this. There's about 30 different industrial sites across the state, Eastern Shore, Western Maryland, Baltimore County, Southern Maryland, etc., where these are eligible sites. So there really isn't any part of the state that wouldn't be impacted by this expedited process potentially the way the bill is written. Am I right on that, Evan? Is that how you're reading it?
Yeah, that's right. And I think it's important to understand that a lot of these generating units were built long before environmental laws existed, and frankly, at a time when racial discrimination was rampant. And because of that, a lot of communities were suffering for decades next to some of these generating units that didn't even have modern pollution controls on them. And so when some of them shut down, it was a relief to the surrounding community, and it would be an insult to just say, well, there was already a generating unit here once upon a time, and so they should be used to it. That's just not, that's ridiculous.
Right.
And you can point to the story at CP Crane, which was a coal plant for decades, shut down. talked about refiring with gas there, and now it's a thanks to Baltimore County, it's going to be a public park, and that was a good result for the community surrounding there that never had a choice as to whether there'd be a coal plant site in their community. Just because it existed in the past doesn't mean that it's, you know, an appropriate place to put a new fossil fuel facility.
And in fact, one could argue it's the worst because there's already been so much pollution in that area. Do we want to be exacerbating that? So I think there's an argument to be made for that. Oh, okay, I see somebody's asking for a list of affected sites. We will get that. I'm not sure we're ready to post it this exact moment. We do have it. We will put it up and get it to you all. Another person, this bill was actually introduced at the beginning of session, and the sponsors are the president of the Senate and the Speaker of the House. So it's considered a leadership bill. That carries a lot of weight. Uh, the members understand that this is a top priority for their leaders. And so it it's formidable. We're really proud of you, members who are weighing in, letting your concerns be known, making sure your elected officials are hearing from you about how you think this needs to move forward. I would say that there's 2 points to make. One is that we want clean energy in Maryland. We want reliable and affordable and clean energy in Maryland. And the other is that the public notification and regulatory requirements section is a non-starter. So we have language, we have an action alert. So just get a hold of us and we can help you convey that information if you need help with that. Oh my gosh, this time just goes so fast. Yes, a decommissioned coal plant would definitely be eligible. In fact, it would be likely. Um, let's see. Yes, thank you, Liz. There's the Cherish Act, which is something that we talked about in previous weeks, really trying to get environmental justice embedded into our permitting process. This is the exact opposite. So, that bill's being considered while this one is considering depleting all of those efforts. There's our we put in our alert, so that's great. And let me see. Kind of wrapping up, the question I circled here that I wanted to have you kind of close things out, Evan, is this is a lot about government and who they represent, and permits and regulations are built on a trust system, right? We have to trust our elected officials, our regulators to take care of our environment, our well-being, etc. How does something that the language that's being proposed here, how does that interfere with public trust? And what do you think the long-term implications of that are for communities and engaging and in process?
Yeah, I mean it's everything. This is a democratic society. Who knows for how much longer, but it's built upon a system that involves individuals, and everybody here has legal rights they may not even understand. But some of the language in this bill is a clear attack on that very notion, that very concept. And so it may be that the bill can easily be salvaged with some amendments. I don't know that I leave that up to the capable people at LCV, but that the language in that bill is just it's tucked away. I think it was hoped by some lobbyists that people wouldn't notice it. Thank God LCV did. But I understand it's limited in scope to just the projects in this bill, but it sets just an awful precedent, a really terrible precedent. And I think people were betting that no one would notice.
Hmm.
But, thank God you guys did.
Well, thank you, Evan. And it is 12:30. So I want to thank everybody for joining us today. As you can tell, Evan is a true ally and a great friend and colleague. So thank you, Evan, for joining us. I hope everybody enjoys a good weekend. And if we have put in the chat, the survey, we've put in our action alerts. Stay in touch. We need your help on this one. We've got a couple more weeks to go, but we're getting there. Take care, everybody. Thanks again.